The time is now 6 p.m. We will now call this special public meeting of the Board of Trustees of Humboldt Independent School District to order. A closed session of the board will now be held on the matters contained in the notice for this meeting. Should the board determine that any final action, final decision, or final vote be required with regard to any matter considered in such closed session, then such final action, final decision, or final vote will be made upon reconvening of this public meeting in open session. The time is now 6:01 p.m. The time is now 6:26 p.m. We will now reconvene into open session. Thank you for joining us tonight. A reminder that the meetings of the board are open to the public but are not a meeting of the public. The board receives the agenda and all supporting documentation several days in advance of the regular meetings, which allows us to ask and receive answers to many of our questions in advance of the regular meeting. Therefore, lengthy discussions are not always necessary on every agenda item, but as a board, we do have the appropriate knowledge and preparation for responses regarding the content of the meeting tonight. There are students and other guests present. To maintain decorum, respectful behavior is expected. Disruptive behavior and/or comments will not be allowed. And with that, our first item, the pledge to the American flag and the Texas flag. Mr. Grabowski.
I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. And now, if you would remain standing for a moment of silence. You may be seated. The next item is public comment. The board encourages comments from citizens of the district or from district employees. Anyone wishing to speak, either as an individual or as a representative of a group, may do so following the procedure outlined on the agenda. The board asks that comments pertain to public education issues and be no longer than 3 minutes. Remember that the board may not discuss or act upon any issues that are not posted on our agenda for tonight's meeting. If an issue mentioned is listed on tonight's agenda, the board will defer discussion until the appropriate time during the meeting. In addition, the board has adopted complaint policies that are designed to secure at the lowest administrative level a prompt and equitable resolution of complaints and concerns. Complaints brought by students or their parents, by employees, and by citizens may be heard in accordance with board policies. Each of these processes provides that if a resolution cannot be achieved administratively, the person may appeal the administrative decision to the board as a properly posted agenda item. Copies of our district policies on public participation in meetings and filing complaints are available on the Humboldt ISD website. And with that, Mr. Scott Ford, please come to the podium, and Ms. Deanie Allen, Mrs. Patricia Fehrenbacher, and Ms. Larissa Fehrenbacher-Powell, if you could come to the very first row of seats up here.
All right, my name is Scott Ford, educator in the district, and full on beginning to enjoy my Thanksgiving vacation. So depending on the outcome of today's meeting, I would hope that given the upcoming board elections, they're not that far away. Over 50% of the board is up for election. Of the 4 out of 7 seats, one individual has made it kind of public that they're not running again. And so big decisions are coming, and I certainly hope that we are allowed to have a new board or the results of a board election in place before there is a search or the hiring of the CEO of the school district so that the community's input could be heard. I think this is pretty much common sense, and I'm hoping I'm preaching to the choir on this one. But again, we only have a few months before the elections are done. And I would hope that we allow those board members whether they're returning or new ones, to also have a say in the future direction of the district. So I'm not going to use my 3 minutes because, I don't want to be that person, but I hope you all have a wonderful Thanksgiving. I hope everybody in here enjoys time with their family and friends. And I'll also point out that even though I'm a teacher on vacation, there's a lot of people sitting in the back of the classroom here. So thank you and happy Thanksgiving.
Thank you, Mr. Ford. Mrs. Patricia Fehrenbacher?
Good evening, members of the board and community stakeholders. My name is Pat Fehrenbacher, and I stand before you today with deep concern for the state of our school district. Over the past months, the action or inaction of the Humble ISD Board of Trustees have revealed profound failures in leadership and accountability. These failures are not minor missteps, they are decisions and behaviors that have eroded trust and compromised the future of our district. You have failed in your responsibility to our community in two critical areas: financial stewardship and listening to the voices of the families you were elected to serve. Time and again, the concerns and pleas of our community have been dismissed, leaving us to grapple with the consequences of your negligence. The handling of the situation involving Dr. Fagan is a glaring example of this dysfunction. The board's reliance on hearsay, questionable testimonies, and a troubling lack of substantive evidence in decision-making reflects an alarming disregard for transparency and accountability. This is not the leadership our students, educators, and community deserve. As trustees, your solemn duty is to act in the best interests of our students, ensuring their educational environment is safe, supportive, and conducive to learning. Instead, personal agendas have taken precedence, fostering a toxic culture that is poisoning our district from within. This cannot and must not continue. Tonight, I demand the immediate resignation of this board. Your collective inability to uphold your responsibilities has jeopardized the future of Humble ISD. The trust our community once placed in you has been shattered. It is time to step aside and allow new leadership to take the reins before TEA intervenes and holds this board accountable for its failures. Our students and educators deserve better. They deserve leadership that prioritizes their needs over politics, personal grudges, or misplaced priorities. To my fellow community members, this is a wake-up call. It is time for all of us to become more engaged and vigilant in holding this board accountable. Let us seize this moment to reclaim our district and ensure the voices of students, parents, and educators are heard. This is our chance to demand better for the future of Humble ISD. Thank you. Let us commit to a brighter, more accountable future together.
Thank you. Ms. Larissa, would you prefer to be Larissa Fehrenbacher? Okay. Thank you, Ms. Powell.
Good evening and happy Thanksgiving. Tonight is a somber moment for our district. While some of you are gloating over the decision of the hearing officer, the harsh reality is there is nothing to celebrate here. We all lost. The situation is both a profound embarrassment and a costly failure to the entire district. Millions of dollars have been wasted in an effort to terminate Dr. Fagan. Funds that should have been directed towards our students and our educators. The irony is glaring. The entire debacle could have been avoided if you had simply chosen not to renew her contract in 2023. After reading the hearing officer's decision, it's clear that the time has come for you to step down. Don't wait for TEA to intervene and force change. If you care about preserving what little integrity this district has left, I urge you to resign now. At the last board meeting, I watched the acting superintendent in open session chastise and criticize a teacher that is employed in this district. Isn't that the very thing that some of the board members testified during Dr. Fagan's hearing and they were scared of was retaliation? Was he punished? Was he reprimanded? While searching for a new superintendent, I sincerely hope that you finally listen to the voice of the community you were elected to represent. It is also time to move away from Walsh & Gallegos, a law firm that has bled this district dry over the past year. Additionally, you must refrain from making any decisions regarding a new superintendent until after the upcoming election. Quite frankly, this board has proven itself incapable of making such critical decisions. Our students, our family, our communities deserve better than what you have shown over this past year.
Thank you, Mrs. Powell. Is Ms. Deanie Allen here? Okay, thank you. Miss Susie Centrone, and if Beth Guide and Keisha Welsh would come sit in this front row, please. Thank you.
It's easier, I guess. Hello, Susie Centrone here. I'm going to say 5 simple items that I've learned over my short amount of time on this earth. If you lie down with dogs, you get fleas. After the salacious read from the Certified Independent Hearing Examiner, whew, I think some people in Humble ISD have fleas on fleas. My mother always told me not to say anything if I don't have anything nice to say, but she didn't raise me a dummy. As what was said before, $1.3 million wasted. Wasted $1.3 million. And you say you're for the kids. And mind you, somebody decided they were going to go look for another job during that time. Whoever is careless with the truth in small matters cannot be trusted with important matters. I think your trust, there's a few of you on this board that have been tested. Not only did our superintendent allegedly allow this behavior, she lied about it, covered it up, smeared other trustees' lives, even having a desperate news interview on a local station to try to cover it up. Sunlight is the greatest disinfectant. Surprised that 3 trustees, Ms. Lamont Dixon, Robert Sitton, and Marcus Holmes, chose to testify behind closed doors. Your game of hide and seek has ended, and it's time we get some trustees who actually care about the children's education and not your personal agendas. The saying power corrupts, absolute power corrupts absolutely, could not be a better description of what has transpired during the past embarrassing few years. The lying, cheating, stealing, deceiving corruption hopefully ends, and we see 3 resignations and a firing tonight. We are tired of the Desperate Housewives rerun, and it's time to put education to educate back in the mission statement at Humble ISD.
Thank you, Mrs. Centrone. Keisha Welsh, is Ms. Guide here? Thank you.
Good evening. My name is Keisha Welch. Thank you for allowing me to speak tonight. As a parent within Humble ISD, I stand here and I can say that we have to put our children back first. What has happened in the school district over the past year publicly, it's been hurtful. Money has been wasted. However, at the end of the night, as adults, we have the responsibility to be role models for our students and our children. As we move forward, I ask that each of you take the time out as you look for a new superintendent, not to look within. The last school board meeting, what I saw with Dr. Brown was an embarrassment, because if a teacher will speak up and their supervisor will retaliate in a public forum, what does that say that is going on in the classroom with our children? We have children that are afraid to speak up. We cannot keep moving forward in the wrong direction. I ask that each and every one of you stop, reflect, look at the negativity, that has come out of this community. We all moved within Humble ISD for a reason. I chose education for my children. And I hope that you guys value education for all children. And I just hope moving forward that we no longer have this negative mark every time I turn on the TV at 5 a.m. and it's Humble ISD, and it's nothing to be proud about. I thank you guys for listening to all the emails that I've sent regards to South Agborn, regards concerns that have been going on and on. But I just ask that everyone stop, take a moment, think about how our students are looking at us as adults. They're looking at you guys as trustees. It's not positive. Thank you for your time and happy Thanksgiving.
Thank you. We will now begin the hearing. So this hearing will come to order. The hearing of the Humble Independent School District Board of Trustees is convened on November 26, 2024 in the boardroom of the Humble ISD Administrative Building located at 20200 Eastway Village Drive in Humble, Texas. The time is now 6:42 p.m. The following board members are present. Mr. Lamont Dixon, Mrs. Lamont Dixon, I'm so sorry. Mrs. Lamont Dixon, Mr. Mike Grabowski, Mr. Robert Sitton, Mr. Ken Kirchhoffer, myself, Chris Parker, Mr. Robert Scarfo, and Mr. Marcus Holmes. For the record, a quorum is present. The next item is consideration of the proposed termination for good cause of Dr. Elizabeth Fagan. Specifically, the board will consider the recommendation of the TEA appointed independent hearing examiner and hear oral arguments in the matter of the Humble ISD School District versus Dr. Elizabeth Fagan, TEA docket number 205-LH-08-2024. Dr. Fagan is present with her legal representative, Kevin O'Hanlon, of the law firm O'Hanlon, Demareth and Castillo. The Humble ISD administration is represented by Craig Wood and Hannah Kramer. Is Katie Payne here? Okay. From Walsh Gallegos, Kyle Robinson and Rolson, PC. Corey Rush of the law firm Spalding, Nichols, Lamp, and Langlaw is present as legal counsel for the Board of Trustees during this hearing. Neither Mr. Rush nor his firm were involved in the proceedings before the independent hearing examiner. Mr. Rush is here to assist the board with legal matters. He is not a decision maker in this matter. In accordance with Texas law and Humble ISD board policy, a court reporter is present. Please state your name when speaking so that the court reporter may record your name. Please avoid talking when others are speaking so the court reporter may accurately transcribe the proceedings. Dr. Fagan made a written request to the independent hearing examiner asking for an open hearing. Does it remain Dr. Fagan's desire for this hearing to be held in open session as well?
It does.
Because Dr. Fagan has requested an open hearing, members of the public are welcome to remain in the boardroom or online to view the proceedings. I will remind all visitors who are remaining to view the hearing to please make sure that your mobile phones are either off or on silent mode to avoid unnecessary interruptions. Out of respect for the parties and their representatives and to ensure that proper decorum of this hearing is maintained, I ask that all visitors refrain from speaking to one another or engaging in any disruptive or distracting behavior. Only the parties, their legal representatives, and members of the board are authorized participants in this hearing. Additionally, following the presentations, the board may adjourn to executive session under Texas Government Code SEC 551 .071, so the board may consult in private with its attorney. However, no action will be taken in executive session. By letter dated August 13th, 2024, Dr. Fagan was notified of the proposal to terminate her term contract for good cause. Dr. Fagan exercised her right of appeal and requested the Commissioner of Education to appoint an independent hearing examiner to hear the matter of the proposed termination pursuant to the Texas Education Code. In accordance with the provisions of the applicable statute, the Texas Education Agency assigned an independent hearing examiner, Karen A. Agbuna, who scheduled and getting feedback. No worries. We're good? Okay. And for the record, I just wanted to state that Mr. O'Hanlon did confirm that you would like to be in open session. I don't think you had a microphone when you said that. Correct? Okay. Who's Karen A. Agbuna, who scheduled and heard the matter. The hearing examiner heard testimony and received documentary evidence on October 31st, 2024, November 1st, 2024, and November 6th, 2024, regarding the proposal to terminate the term contract of Dr. Fagan for good cause. The hearing examiner then issued her recommendation. The hearing examiner concluded that the Humble Independent School District sustained its burden by a preponderance of the evidence to terminate Dr. Fagan's term contract for good cause. These items are set forth more fully and discussed in the hearing examiner's recommendation. The board's objective is to consider the hearing examiner's recommendation, allow each party to present an oral argument, and determine whether the hearing examiner's finding of fact and conclusion of law should be adopted, rejected, or changed. After hearing presentations from both parties, it will be the board's responsibility to announce a decision that either adopts the hearing examiner's finding of fact and conclusions of law, or rejects or changes the hearing examiner's findings of fact and conclusions of law. This hearing will be conducted as a hearing on the record. The hearing before this board shall be based on the transcript of the hearing before the hearing examiner and all exhibits admitted during the hearing, and no new evidence shall be submitted or accepted prior to this hearing. Prior to this hearing, all board members received copies of the record on which this hearing is based. According to Humble ISD board policy, each party shall be allowed 10 minutes for oral argument. The administration shall be offered the opportunity to present argument first and may use a portion of the designated time for rebuttal after the other party has presented their argument. The board reserves the right to grant additional time in equal amounts to both parties, depending on the complexity of the issues, and that is solely at the board's discretion. Both sides shall be available for questions from the board after their respective presentations. After deliberation, the board may announce its decision. The board may consult privately with its attorney at any time. Are there any questions regarding the manner in which this proceeding will be conducted?
I have several.
Mr. O'Hanlon is walking to the podium and
Yeah.
has questions.
These are procedural questions. This is an argument. There is a court reporter here that she had not been identified. Could you identify yourself for the record, please, ma'am? Can you repeat that? I can't hear it.
Jennifer Ivanek
All right.
with Magna Legal Services.
Can I get a card at all right, thank you. With respect to the record, I don't have it. And it's not an idle request. The requirement under Texas law, specifically 21-258A, requires that the hearing officer deliver a copy of the record to you prior to conducting this hearing. Has that been done?
The board is in receipt of the record.
Pardon me?
The board is in receipt of the record.
Has it not received it?
Is in receipt of the record.
Of the record. I would like to examine it, and that there are the issues with respect to correspondence in this prior to proceeding further. We have not received a copy of the record from the hearing officer, and I'm requesting one.
Objection is noted on this record.
Pardon me?
Your
My objection is what?
noted on the record, so you may continue.
All right. And I would like to stand down so I can get the copy. There's a series of correspondence back and forth with respect to this hearing that took place that is relevant to the consideration, will be definitely relevant to the consideration of the matter on appeals. A number of pre-hearing orders that were done both by letter and email, and I want to ensure that those are included in the record. Without examining it, I cannot do that. And this is my only chance to do that. So noting it for the record is not sufficient in order to allow us to identify the issues or the documents that should be in the record. I don't think there's a dispute. There are the emails back and forth. I just don't have them. The only transmission I got from the independent hearing officer was a transmission last night of the decision itself, not of the record. I don't have the record. So I'm looking for a copy of the record before we proceed.
I do not have a physical copy to hand you. Oh, I tried to press the button, sorry. Sorry, my green button does not like me. I do not have a physical copy of the 7,000 or so pages of this record to hand you, but my suggestion would be that if you are asking for particular items that should be included in the record, that you please note them during your presentation, and we can confirm that they are indeed part of the record going forward.
How can I do that without seeing what's in the record?
Presumably, since you participated in the hearing, you would know what is in the hearing record.
I do not have another chance to certify that these are in the record that will be transmitted to TEA. Since the board is the one that's transmitting them, then presumably they're going to take action tonight. How am I going to ensure that those are included? The hearing officer's lost jurisdiction of this. How am I going to ensure that all of the documents are included in the record? That's what I'm asking how to do. Right now, I have not been afforded a copy.
And I'm going to be careful not to provide with you or your client with legal advice here, but you have the opportunity upon appeal to the Commissioner of Education to certify that the record is complete and to supplement it if necessary, if what the school district provides to the Commissioner of Education along with its answer is not a complete version of the local record.
And how would I do that under the rules, under the rules for procedures before the Texas Education Agency? There is not such a procedure in Chapter 19 TAC 157.
I believe that there is, but I'm not going to sit here and argue with you, but there is an opportunity.
Could you identify that for me,
Off the
please?
top of my head, no, but I know that you can supplement the record. And you can ask for when the school district provides the record along with its answer in an appeal, if an appeal follows, you have the opportunity to request that the record be provided to you. And if the record isn't complete, that is something you can bring up with the Commissioner.
I am requesting that a copy of the record be provided for me
which
right
is on
now.
appeal, sir.
Before the hearing, before the only hearing that I'm going to have before this board.
Your record, your objection is noted on the record.
Pardon me?
Your objection is noted for this record. I don't know what else to say.
I asked that it be ruled upon, and you don't have the authority to rule upon it.
Correct.
That's a
Nobody on
board
this
determination.
has any authority to rule upon an objection. You have stated it for the record. We have a court reporter here. This is obviously something you can bring up on appeal.
Second, please note for the record that that we are invoking this hearing under 551.074B of the Texas Government Code. Deliberations with respect to this matter are required to be in public. Are you aware of that? board deliberations when it's an open meeting are required to be in public.
Correct.
All right. So you're going to instruct them that no deliberations may take place in closed meeting.
The board has been advised that Dr. Fagan has requested an open hearing and that you, as you heard Ms. Parker state, we may go into closed session for legal advice, but deliberations will occur in open session as requested by Dr. Fagan.
All deliberations will be in open session.
There's an echo. Yes, all deliberations will be in open session.
All right. That's all I have with respect to my objections. Note our objection. I still don't understand how we're going to get a certified copy of the record. Who's going to certify it?
In the event of an appeal from any decision that the board makes tonight, the responsibility of the school district to answer a petition for review to the Commissioner of Education requires the school district to not only answer said petition, but to provide the local record as developed before the independent hearing examiner to the Commissioner of Education and to the party who appealed upon request. And if that record happens to be incomplete, you and I both know, having practiced in this area of law for as long as I have and as long as you have, that you can bring up objections to the completeness or incompleteness of the local record with the Commissioner of Education and handle any procedural irregularities that may arise from that situation with the Commissioner of Education.
I'm aware of the certification of the record requirement. I'll direct your attention to 21.258A of the Texas Education Code that requires the hearing officer to deliver a copy of the record. That's what I want. I don't have that. And your response is, I don't get it. Is that, but I have to proceed in this matter without having a copy of the record. Is that?
I'm not instructing you how to proceed. I'm
ask
just
for the-
noting that you have already stated this and we can move on.
I'd ask for the board's determination with respect to that request.
There is no board determination allowed with respect to that request. Your objection is noted on the court reporter's record.
So you're denying the vote on that at this point?
I am not denying a vote. That is not a vote that is on the agenda for this board to take. Your objection is noted on the court reporter's record.
Noting it is not a ruling, counsel, you know that well. Noting it is not a ruling on an objection. It's
I will
either
note
granted or denied.
your objection to the objection process. I don't know what else to say. Thank you.
I'm making an objection to the objection process. I'm asking for a ruling on that objection. I'm entitled to that.
Council, you made your point. It's on the record with the commissioner. There is no division.
For the record, the board is refusing to provide me a copy of the record before proceeding further in connection with the deliberations of this.
Mr. Wood?
Madam President and members of the Board of Trustees, this may be one of the strangest closing arguments that I've ever made because of the nature of this process. I don't want to first focus on the facts or the conclusions of law because you have a 30-page document in front of you that tells you what the facts that are operative in this situation are. You need look no further than public comment to realize that different people can view the same set of facts differently and come to different conclusions. But in Texas, with respect to the termination of a Chapter 21 contract employee, a superintendent like Dr. Fagan, there is a process that must be followed before you can separate your employment with that employee. And that process involves an independent hearing examiner. This 30-page document doesn't reflect my set of facts. It doesn't reflect a set of facts that you have come to. It reflects a set of facts that were presented in a due process proceeding. We're given in eight different depositions and 3 full days of testimony involving the presentation of hundreds of documents. And the independent hearing examiner listened to the presentation of that evidence, listened to the presentation of evidence that was given on behalf of the school district, and also listened to the presentation of evidence given by Dr. Fagan and her counsel. She had the opportunity to rule on whether or not that evidence was admissible, whether it was relevant. There were certain issues that dropped out during that process. But after reviewing that, she wrote this opinion and she made findings. She made findings that she believed accurately reflected the state of the evidence at the conclusion of that hearing. That's her job to do that. It's your job to consider that and to decide what you do in taking into account the recommendation that she made. So I'm not going to belabor all of these facts. I know that you've had the access to read them. What I am going to tell you is just from a 10,000-foot view, I'm going to just share with you portions of the written closing argument that we submitted to the independent hearing examiner at the conclusion of the hearing. And what we told the independent hearing examiner was that Dr. Fagan's conduct has resulted in an unbridgeable chasm between her and the board. There was testimony that the relationship between Dr. Fagan and the board is irrevocably broken for several reasons. And there was also testimony from district employees as to why Dr. Fagan has not and cannot fulfill her duties to the district. One common theme that was very prevalent, I know many of you have had the opportunity since that time to watch the entire proceeding, but one of the common themes that showed up over and over again is that significantly Dr. Fagan's judgment was compromised by her relationship with her indirect subordinate. Her relationship with Mr. Kite resulted in favoritism towards him and his department rather than assuring that all of your employees received equal treatment. The relationship also caused her to shirk and neglect her duties as superintendent of the district. There was testimony that she spent hours at a time sitting in Mr. Kite's office. And the comment was made during that presentation that that's not really what a board hires a superintendent to do. To the tune of nearly $500,000 that you were paying her, you would have expected that she did what her contract required her to do, and that was to faithfully perform her duties with reasonable care, diligence, skill, and expertise. That did not happen. Now, I'm not going to get deep into the facts because, again, you have them, but damningly, she allowed employees to be exposed to harm and harassment. She sat idly without comment or action while Mr. Kite had temper tantrums, broke district property, and stormed out of meetings. Shockingly, she was aware of Troy Kite using inappropriate and sexually charged language in communicating with his subordinates and others, and she failed to take any type of remedial action. Because of Mr. Kite's relationship with Dr. Fagan, employees felt that they could not report his behavior out of fear of retaliation. When an employee finally did step forward, and you'll recall this happening in May of 2023 when we first met, to report Mr. Kite's behavior directly to the board, realizing that Dr. Fagan was already aware of this conduct and had declined to intervene in any manner, Dr. Fagan sat by while the process cost the district millions and created a huge disturbance within the district and amongst its constituents. She misrepresented and failed to disclose significant facts to the Board of Trustees, which impaired your ability to make decisions. She failed to disclose her relationship with Mr. Kite prior to the board's consideration of the reorganization, elevation of Mr. Kite's position. She then misrepresented to members of the Board of Trustees when the relationship actually began. Indeed, even your Assistant Superintendent of Human Resources, who's charged with making organization and salary decisions, was not even informed of the relationship until after the filing of the Title IX complaint in May of 2023. You'll recall that she did not inform the board for well over a month upon receipt of a Office for Civil Rights complaint, even though she realized it involved a Title IX matter. And she knew that Title IX matters were a major source of concern for this board. If you've read the testimony that was presented, and if you watched the testimony, you know that she spoke of the board in very derogatory terms, in terms that were insubordinate in employee evaluations. I will agree with something that was said earlier, that all of this could have been avoided. You couldn't have avoided it because you had this relationship. And until the evidence existed for you to make the recommendation that you did, and until this process played out, there wasn't anything that you could do about it. A whole lot of these things you didn't even know about until these investigations took place. I mean, think about the things that you have learned during the course of these various investigations. Think about the things that you have learned during this process, even the things that you may have learned since the time that you voted to propose the termination of her contract. But Dr. Fagan could have avoided it. She could have avoided by simply acknowledging that her relationship with Mr. Kite had run afoul of your board policy DK local. Your board policy DK local speaks to a couple of situations. It speaks to when a relationship has become disruptive. Now, I can certainly see the argument that until there was a complaint about Mr. Kite's behavior, it may not have become disruptive, but certainly after that point. But rather than backing down at that point and telling Mr. Kite, one of us is going to have to go, instead she married him, which is a clear violation of your board policy DK local. I'm just going to skip right to the end and let me tell you that some deficiencies in a superintendent's performance are remediable. Some are simply not. Lying, deception, insubordination, and the failure to maintain an effective working relationship with the board fall into the latter category. We urge you that you adopt the hearing officer's recommendation and terminate the employment of Dr. Fagan.
Thank you, Mr. Wood. Mr. O'Hanlon? You'll have 10 minutes for your presentation.
All right.
Mr. Rush will keep the time.
Madam President, members of the board, we're looking at a decision that in front of you tonight. And then the reason why this matters is that, in our opinion, the decision is highly flawed for a series of reasons. One, the hearing officer made a determination in the case that we could not access any of the Title IX investigations. And yet, in 6 separate occasions, the hearing officer cited testimony that was pulled directly by trustees or other witnesses out of the Title IX findings, objected to as hearsay, and yet they found themselves in the final decision. That's a violation of the Texas Rules of Evidence. It's a violation of due process of law. And it's a violation of the procedures under Chapter 19, TAC 157, under which these hearings are operated. So the Chapter 21.306 G of the Texas Education Code says you can't reverse a decision unless the error was likely to have led to an erroneous result. It did in this case, because the hearsay is used to support the case when there is absolutely no evidence. There's no evidence that Dr. Fagan had a relationship before it was disclosed to the board on March the 26th of 2022. There's speculation. There's people saying, I heard somebody said, but there is no evidence. I heard somebody said is hearsay. It is not admissible as evidence under the Texas Rules of Evidence. It's just not. So that's what we've got. That's what we're looking at in this case. So that's specifically, but it's more important than that. Dr. Fagan told the board of the relationship on March, as we said, March 26, 2022. The board had no objections to it. The board renewed both her contract twice after that disclosure, and they renewed Mr. Kite's contract twice after that disclosure. In May of 22 and 23 with respect to Kite, in April and June of 22 and April, July of 22 and April of 23 with respect to Dr. Fagan. So the board knew about the relationship and yet renewed the contract in terms of that. Now, the whole issue with respect to that, I was astonished during the course of the testimony in this case by the following. Mr. Grabowski, you said, and your testimony is, and it's in one of the findings, that you what tore it with you with Dr. Fagan is the fact that she testified against Mr. Scarfo. It's on the record, it's quoted in the findings. That is Title IX retaliation. Her testimony was compelled under the provisions of Title IX. That is Title IX retaliation. Mr. Kirchhofer, you said in your testimony that the problem is that Dr. Fagan did not terminate Mr. Kite's contract after he filed the complaint against Mr. Scarfo in the summer of 2022. Yeah, that's on the record. Your testimony is under oath and on the record. That's Title IX retaliation. That is an absolute gut-cinch violation of Title IX. If your lawyers aren't telling you that, they're not paying attention with respect to that. So what the objection to that and the Title IX investigations are absolutely important to this case. The point is this, with respect to Dr. Fagan, I understand the impulse that to lash out when an employee like Mr. Kite files a complaint against a trustee. I do. It's human nature. But lashing out is prohibited by the specific provisions of Title IX. You cannot retaliate against someone for filing a complaint. You can't do it directly by going against Mr. Kite, and you can't do it indirectly by going after Mr. Kite's Dr. Fagan in order to compel him to do that. That testimony is in the record. Mr. Scarfo, you said something very similar to that in your direct testimony to that. So we've got three folks that have confessed to Title IX retaliation in this case, on the record, under oath. So now, back to this issue about making a determination. It is uncontested in the record of this case that on May the 4th of 2023, the day that the complaint got filed by the assistant athletic director against Mr. Kite, Dr. Fagan was removed from having anything to do with Mr. Kite by action of the board. She was told not to do anything. Everybody testified to it. Dr. Fagan testified to it. All the trustees had testified to it, that she couldn't have anything to do with this matter. And yet, Mr. Woods is arguing that despite being taken off the case and despite the notion of retaliation under Title IX is prohibited by both the statute and law, and also by under Title VII, which is pulled into this as well, that Dr. Fagan should have taken an action to retaliate against Mr. Kite. Even though the board couldn't do it, you knew that. You knew that, and the frustration grew and grew and grew because you couldn't get it over with. You couldn't get it over with because you couldn't finish the investigation. You never finished the investigation. The investigation against Dr. Fagan is still going on. A year and a half later, it's not over. It's still going on. Your policy says 15 days. Business days, it's working days, but 15 business days in order to resolve a DIA complaint. You didn't do it. So the disruption in this case is that, and I understand the impulse against that, but the employees that testified, you have experienced staff in this district, the interim superintendent, who was the deputy, you had a Title IX coordinator. All of them are experienced and trained folks that had the ability to handle this, and you took it away from them. And then you guys were said, have we all been trained on this? No, you haven't. I don't know. I understand that. Has Mr. Wood been trained on this? No, he hasn't. Has Mr. Woods told you that that training is a requirement? No, he hasn't. Has Mr. Woods told you he's got a conflict of interest because he's a witness in the case? No, he hasn't. So with respect to the issues that are out there, this whole thing should have been decided. But this notion that you're mad at Dr. Fagan for not taking action against Mr. Kite after you took the authority away from her to take that action, which everybody admitted that you did, is astonishing. So you're holding her responsible for actions that she didn't take because she couldn't, because you prohibited her from it. And such actions would have been retaliatory anyway. And you wanted her to do that because you couldn't and you knew it. This is we think this case is going to get reversed on appeal. There's tons of error in the hearing officer's decision. It's going to, and this case is going to go on as a Title IX investigation for some period of time in terms of that. We think you should put Dr. Fagan back to work. Despite the fact that there's a breach of trust, there was not a single action that anybody testified to that she did, that she actually took, not that what you heard somebody did, that violated any directive of the board. Just didn't. So you said that the lawyer did it, and you thought that she was involved in it, but she wasn't. There's no testimony with respect to anything. We're asking that you reinstate Dr. Fagan and go back to work and all of the Title IX investigations now and get back to work educating kids.
Thank you, Mr. O'Hanlon.
Mr. Wood, you have 1 minute and 11 seconds remaining.
I'll just briefly note then. The statute pointed out by opposing counsel 21258 does not require that you provide him access to the record. Even without the Title IX stuff, if you threw everything that related to Title IX out as you read this decision, it's still clear that she engaged in misconduct, that she failed to maintain effective relationship with the board. She engaged in a disruptive relationship with Mr. Kite. She lied about the TEA complaint. Mr. Grabowski's testimony is being taken out of context, as were the others. What he said is that he felt like she had participated in a false scheme against an innocent man, and that on the basis of that, she should not be superintendent of the district. Additionally, I'll just add that I'm not a witness to anything other than to the presentation of the evidence that was presented to the independent hearing examiner. She assessed that, I believe, in a reasonable manner.
Thank you, Mr. Wood. Are there any questions from board members for the parties? Mr. Sitton?
Yeah, just to clear up something that was said earlier tonight. And when I was reading through the record, I was confused. And that was, I was requested, actually subpoenaed twice to give a private deposition. Then when it came time for the actual hearing, crickets. So for someone to say that I hid and that I gave a deposition in behind closed doors, silent, is absolutely false. I was subpoenaed to do that. I was not subpoenaed to appear in the actual hearing. And so when I'm looking through the record, I'm kind of curious why, and I don't know who the question is to, but why there was no reference to my subpoena in any of the documents that I saw, or did I just waste 2.5 hours of my workday? So, I mean, it's maybe more of a comment than a question, but just to clear that up.
Ms. Lamont Dixon?
Yes, and to piggyback on that, I also had that as a note to clarify. I actually was not subpoenaed, and I was not asked to testify, and I did not testify behind closed doors. I was never questioned in this matter at all. So I just wanted to make sure I stated that for the record, since there seems to be some confusion on that.
Mr. Holmes?
Yeah, same. I think the question I have as well is stating exactly what Mrs. Lamont Dixon shared, as well as Mr. Sitton. I thought I was going to testify. That never happened. Don't understand why. And I did actually have interview testimony last week with the TEA. But again, was not asked to testify at all, although I thought I was. So again, was not hiding, was not trying to avoid any of that. And again, I would also like to know why I wasn't called.
Is your question to Mr. O'Hanlon?
I don't know who that's to. I don't know. I was just wondering.
I'll jump in just to say that we are limited to the record before the hearing examiner, so kind of by its nature, except for Mr. Sitton, who did provide deposition testimony, which would be in the record before the hearing examiner. Ms. Lamont Dixon and Mr. Holmes, since y'all did not provide testimony, obviously that would mean that the evidence is not in the record before us today.
Any further questions? The parties have completed their presentations, and it is now time for the board members to make our decision on the issues before us. We must either adopt the findings of fact, conclusions of law, and recommendation of the hearing examiner, or reject or change the hearing examiner's finding of fact and conclusions of law, and propose a grant of relief. Does any board member wish to obtain legal advice on this matter in closed session? It is now time for us to make our decision on the issues before us. Any action we take must be supported by the record presented to the certified hearing examiner. Is there any discussion? Mr. Sitton?
Thank you, Madam President. I know it's no secret, I've challenged this process since the beginning. My feelings haven't changed on that as far as the process, the way things have gone down. However, upon conclusion of this matter by majority vote tonight, I will accept the results. My hope is we will be able to move forward as a unified body and begin the healing process. Our community deserves that. I look forward to the planning and the process in whatever manner as we move forward with a potential superintendent search, refocusing on what is most important, our students, our staff, and our community.
Ms. Lamont Dixon?
Mr. Rush, is this the time for us to have discussion without the motion, or I'm just confused on the process right now?
We could do this through a motion, but right now we're just deliberating if you've got any thoughts on the record, or we can go ahead and take the motion and have deliberations either way.
Okay, Madam Chair, may I go ahead and continue then?
Yes.
Yes, I think what I would like to say first, actually, And reading findings and hearing things throughout, I think, and even at the last board meeting, apparently, right? So the first thing I wanted to say is that as a board member, it's my true belief that no employee ever should feel afraid to speak up for themselves in a school district or in any entity. And I just want to say to employees, please know if you ever feel that you cannot speak up and you reach out to your supervisor or you don't feel comfortable reaching out to your supervisor or their supervisor or a person in charge, just for the record, you always can reach out to the board. There is a mechanism in place, and no employee in any entity, especially a school district, people should not ever feel like they cannot get the assistance and support that they need. I think what Mr. Sitton said a little bit earlier is essentially my feeling. I know tonight the attorneys talked about process. I know Mr. Woods talked about process. I feel that the process of how we got here was not done correctly, in my opinion. And when I say that, I'm not saying that the attorneys did anything wrong or anything like that. That's not what I'm saying. What I'm saying is initially we put someone on leave, and that reason then changed when we went to termination. So why would the reason change? And then even when we got the findings, there were things that were essentially brought up and discussed in the findings that was not part of the reason, in my opinion, that we terminated. It just seems like it wasn't smooth to me. If the first reason that a person was put on leave, Dr. Fagan, if that was the reason, then why would that reason change throughout the process? And then why would there be additional things in the end? I do have challenge with that. I have challenge with the reasons changing along the way. So when I say, to me, the process was an issue, I believe that, yes, I'm sure all of us here, there were things that surprised me when I read the findings. There were things that predated me as being a school board member that were shared, whether it's hearsay or true or what have you. But, you know, I just don't like the way we got here. And I don't know why it went that way in order for us to get here today. And I'll probably maybe have some more of the comments later, but that's what I wanted to say at this moment.
Anybody further?
Madam President?
Mr. Scarfa?
Yeah, thank you. I'm really not following Mrs. Lamont Dixon about what changed. I don't see that anything changed. The process was the process. And I think it was handled very well because of what we had to do as a board and what we couldn't do with our internal structure or apparatus, if you will. So I'm sorry, but I can't agree with a statement like that, that things changed. Nothing changed from the leave of absence to where we are here. The leave of absence was for a specific reason. Okay. And what happened since then with when the proposed termination was made was for a myriad of reasons. And you saw them, every one of us saw them. Okay. And then it moved down the track that way. So I just can't agree with that summation that things changed. Thank you.
Can I respond? May I please respond?
Mrs. Lamont Dixon?
And I think you actually kind of said what I said. I mean, I think, yes, there was a leave for a particular reason. And then the second piece was a myriad of reasons that did not include the initial reason. So that's what I'm saying. It was not the same thing.
Mr. Holmes, may I have a motion?
I move that the board adopt the findings of fact, conclusions of law, and certified hearing examiner's recommendation in the matter of Humble ISD versus E. Fagan, docket number 205-LH-08-2024, and that the board terminate Dr. Elizabeth Fagan's employment contract with Humble ISD for good cause effective immediately.
Do I have a second?
Second.
The motion has been made and seconded by Mr. Grabowski. Is there any discussion? Mrs. Lamont Dixon?
Just another point that I wanted to make. I feel as a board member, you know, as a board member, we are technically the boss of the superintendent, right? And I just would hope in the future as a board member that if any board member ever had information or issues with the superintendent, it's really my opinion that they should have called a meeting to discuss that and put things in place or discipline or what have you. The issues that people raised, in my opinion, as a board member, I did not know about until they were raised in a moment of saying, let's terminate. There was nothing in advance of that, nothing in writing, no conversation. So I just hope going forward that we do better. I mean, I think we owe it to employees to give them due process. And yes, there was due process after the fact, but what about prior to that? I think it is important as a board member to make sure that we treat people with dignity and we make sure that if we have an issue, that we're actually discussing it and talking about it and putting things in place before we ever get to where we've gotten to. And to me, that was not done. I mean, I heard stories from different board members, and I'm not saying those stories are not valid. Maybe they are, but why did we not know that? And I know Mr. Kirchhoffer, he says that there was a conversation with him and Dr. Fagan, but how can one board member have a conversation with the superintendent and basically saying you need to leave your job, or, you know, if you don't get this job, you know, it's time for you to move on? No one else had had that conversation. Like, who else? Like, one board member cannot make that decision alone and have that type of conversation with someone. That should be brought to all of us to say, this is an issue. This is what we talked about. Not just finding out when we're talking about termination. Like, I just don't think, and Mr. Kirchhoffer, I'm not trying to pick on you by any means, but I'm saying there were so many feelings amongst other board members that were never shared with the full board for us to address this in advance. And I just don't think that's the way we should do business. It's not what's best for the district. It's not what's best for the students, the teachers, none of that. So I just want us to do better.
Anybody further?
Madam President. Yeah.
Mr. Scarfo?
Again, I'm going to have to wholeheartedly disagree with that summation of that it was I don't believe this wasn't, in my opinion, this wasn't about feelings. This is about findings of fact. And, you know, you don't know what you don't know. And when you find out, as investigations begin to go down the path, well, then you learn new information. And I think you're really mischaracterizing, I don't mean to speak for him, but Mr. Kirchhoffer, in terms of his role as the board liaison, he didn't offer an ultimatum. As I understand it from what he explained to us when asked about it, was that's what he was told. So I don't like to hear that said, that he was trying to make a decision for the board, because I don't believe at any point he tried to do that. And I'm not being biased because I was the one as the time as board chair to choose him to be the board liaison, working with outside counsel. So I just want to make that point, again, my opinion.
Mr. Kirchhoffer?
Yeah, I don't want to just distract from what we're about to do, but I spoke to the entire board in a closed session about a conversation with Dr. Fagan. She was up for the Colorado job. She was put on the agenda. She was going to be put on the agenda for that meeting. She asked me not to put her on that agenda. She asked me not to. Why? To wait to see if she got that job. And Dr. Fagan told me, you'll have my resignation one way or another, I get the job or not. She told me that. I got off the phone. You already all know this. I called the attorney, called her back. There's no threat, no telling somebody what they can do or not.
I'm going to recognize myself real quick. What I would say is that if the STAR scores were down, we would have in superintendent evaluation put Dr. Fagan maybe on an improvement plan or made that a priority to improve the STAR scores. But there is no improvement plan for ethics, and a lack of candor. There's no improvement plan for that. There's just not. Mr. Sitton?
So I'm going to disagree on some of that. I agree with everything you just said. I think the challenge is when Dr. Fagan was initially put on leave, and then the initial vote to propose termination, a lot of the stuff we saw in that 30-page memo or release today was not discussed. So the challenge that we had was coming out and voting when we haven't talked about what those challenges were, what was going on, why, and Mr. Kirchhoffer did explain to us the conversation he had prior to coming out to make that determination. But again, the investigation really happened after the proposed termination was passed. So a lot of the fact finding, if you will, did not occur until after the fact. And the problem I had with that was, how can we propose termination without having a board discussion, without finding a determination of a reason why we would do that? So now we're down the road and proposed termination has happened. We've gone through the independent hearing and all that stuff. So it's a moot point. But I would agree with everything you said. I would agree with everything Ken said, and I would agree with everything Ms. Lamont Dixon said. But the idea that we make a decision that is this impactful in our community, and yet the board never even had a workshop or a team of 8 conversation to talk about challenges or problems or potential issues that we may have had or may not have had to discuss, and then be prepared instead of the way it happened. At the end of the day, would it still turn into where we're at today? Very well could have. I don't know, but we didn't do the work on the front end. It's my opinion.
Mr. Grabowski?
It's a little of my opinion on how we got here. Once we proposed termination, a lot more information came out. So the record, unless I heard it, saw it, or as part of it, that's all I would know. And then I got to see everything that all the other employees experienced through this whole dysfunctional mess that became Dr. Fagan and her husband, largely. Now, let's go back to the proposed termination, and you're hearing This was faulty. This was a bad investigation. I haven't seen the evidence. There were 3 trustees that walked out of closed session as Mr. Wood, our counselor, was beginning to show us that evidence. And then we came back up here and talked about it. So if they hadn't seen it, that's on them, because that opportunity was afforded to them. That's why there were some very bad starts to this. We didn't work as a cohesive group. We didn't let the attorney, all 7 of us, do that Mr. Wood should have been given the right to do. That's part of the reason we had that very awkward start. But all the evidence that came out afterwards is something we all got to see in the 30-page document that we received yesterday evening. Thank you, Madam President.
Mr. Holmes?
So, Mr. Grabowski, I'm trying to recall, I don't think I ever walked out, unless you're maybe not referring to me. I don't ever recall a time when I walked out when evidence was trying to be presented in terms of context regarding Dr. Fagan and her actions. So can you jog my memory? I just don't remember. I don't remember ever walking out. I do remember on that night, that Tuesday, I believe we were given 10 minutes. I believe it was around 6:50, approaching 6:55. Board meeting starts at 7. And I actually was in agreement with, I think it was Mr. Scarfo or Mrs. Parker, that we did need to start on time because we had had quite a few closed sessions that were carrying over, and we did not want the public to have to wait on us. But we were given literally less than 10 minutes to deliberate on the job of our superintendent of almost 50,000 students that makes $500,000 a year in the span of 10 minutes with limited information. And I've said it then all the way to now. It's not the how. I mean, it's the how. It's how we did it that I have always had a problem with. Now that I have a lot more context, nothing that has been shared do I have an issue with. It's the how. But help me understand. And if you're saying, so if Mr. Wood can share, I've never walked out of a meeting mad or upset or saying, I don't want to see it. I've actually been on record in open session saying, I don't have enough information to make decisions as it comes to Dr. Fagan, Mr. Newman. And so I just don't understand. Help me though, because Mr. Grabowski, if I did it and didn't even know I was doing it. So I know that you brought Mr. Wood in. Please tell me what I may have missed.
Madam President, I don't know if that's appropriate to ask counsel in this deliberation.
That's correct, Mr. Holmes.
Okay.
If you would like to go into closed session and
I think it's a moot point, but I do want to say again, it was the how that I've always had an issue with. And Ms. Parker, I'll tell you, I respectfully disagree, but I understand where you're coming from. I have employees, and I've been a people manager for quite a while. You absolutely can put somebody on a behavioral improvement plan. If you're not in favor of their behavior, you can put them on that. And the problem is we provided no documentation to Dr. Fagan in writing. We did the same thing with Thomas Newman, nothing in writing. However, this is one thing I do see, and this is in our board policy. There are 4 board members at that time that had lost faith in Dr. Fagan being able to lead this district. That is a majority of this board. And that is where the issue lies. And I have seen from that point on that it was unrepairable. And that is in our board policy. And so I can't, when it chooses, when it's good for me, not look at it. I have to abide by the board policy, and I'm looking at the majority of this board that does not have confidence in Dr. Fagan. And again, now having context, and the community knows I'm a zeros and ones kind of guy. I'm an engineer. I like facts. So some of this independent hearing was hearsay. A lot of this, though, was based on facts. And that's the problem that, again, I want to bring up. It was the how. So we're going to make our decisions. But again, I just appreciate this independent hearing examiner. She has no skin in the game, and it's objective. And she looked at the preponderance of evidence from witnesses. And again, now we have to make our decision. But I do not agree with anything that anybody has said. I just want to make sure the community is aware. I never walked out of any meeting knowingly or unknowingly not wanting to hear. And again, please let the record reflect, I've always been adamant that I needed more context to make decisions, and I was not given that opportunity.
Anybody further? Mr. Scarfo?
Yeah, I'm sorry. I just, one last thing then, and not ask you to call the question, but to say that all of a sudden, after placing the superintendent on a leave of absence, all of a sudden revelations just started to fall from heaven. That's not true. Okay. And again, Mr. Holmes, I'll take exception to you saying you didn't have information. We had information over a period of months. It was coming out through investigations. It was quite clear. I mean, this wasn't just hearsay. It was corroborated by numerous witnesses. Okay. So we saw what was going on. And yeah, I'll tell you, there were some new things that came to light to me through the this but again, for anyone to say that all of a sudden it just happened like magic, it's not true, because this played out over a number of months and through these investigations, and people needed to pay attention. Okay. And I'm just going to leave it at that, but I take exception for anyone to try to paint a picture that's not accurate.
Mrs. Lamont Dixon?
Yeah, I just wanted to clarify, Mr. Grabowski. Yes, I think we had about 10 minutes to talk about the superintendent's termination, and I did leave a few minutes early, so I don't know what I missed when Mr. Woods spoke in those few minutes that we had left. But there was a reason that I did that. I knew that if I made my comments about the information that was shared and closed, then I would not be able to speak about them in public. So I made a decision in my understanding, that's when we were starting to share our opinions and have discussion, but maybe there was a piece of information that I missed in those last few minutes. Not totally sure, because I did leave out of executive session, but it was because I wanted to share my concerns and my thoughts and opinions in public. So just wanted to clarify.
Mr. Holmes?
Yeah, and just to clarify, Mr. Scarfo, I see where you're coming from. Let me clarify. I was talking about on that particular night. And you're right, there were Title IX investigations coming, but they were not concluded. They had not ended. A lot of them were still in process. So you're right, we were getting a lot of information, but I'm talking about on that specific night, how we placed her on leave, Dr. Fagan, is who I'm referencing. That's where I had an issue. But you are right. We did have information, but as I was shared with by attorneys and under their recommendation, that we needed to let this play out so we could have all the evidence in order to make the right decision. And that's where we are right now.
Anybody else? Before we vote, will you please reread the motion?
Yes, I move that the board adopt the findings of fact, conclusions of law, and certified hearing examiner's recommendation in the matter of Humble ISD versus Elizabeth Fagan, docket number 205-LH-08-2024, and that the board terminate Dr. Elizabeth Fagan's employment contract with Humble ISD for good cause effective immediately.
All those in favor? Opposed? Item carries 6-1. A letter notifying both parties of the action of the board shall be prepared and signed by the president of the board as soon as is practical. For the record, however, the board has announced its decision for the purpose of the Texas Education, Section 21.259. This hearing is concluded at 7:50 PM. The parties may be excused. Board, let's recess back into closed session under 551.074. A closed session of the board will now be held on the matters contained in the notice for this meeting. Should the board determine that any final action, final decision, or final vote be required with regard to any matter contained in such closed session, then such final action, final decision, or final vote will be made upon reconvening of this public meeting in open session. The time is now 7:50 PM. Rusty, are we good? The time is now 8:25 PM. We will now reconvene into open session. Item 4B, consider and take possible action regarding any and all employment-related actions regarding the superintendent and/or acting superintendent as may be necessary. Mr. Holmes, do I have a motion?
Yes.
I move that the board appoint Dr. Roger Brown as an interim superintendent of the district at his current acting superintendent rate of pay.
Second.
Motion has been made and seconded by Mr. Scarfo. Any discussion? All those in favor? Item passes 7-0. So item 4B still, consider and take possible actions regarding any and all employment-related actions regarding a superintendent and/or acting superintendent as may be necessary. Do you have a second motion, Mr. Holmes?
Yes, Madam President. I make a motion to move that Associate Superintendent Mr. Rick Gardner post the position of Superintendent of Schools on or before December 2nd, 2024, so that the board can consider hiring a superintendent of schools at a subsequent board meeting.
Second.
The motion has been made and seconded by Mr. Scarfo. Is there any discussion? Mr. Sitton?
I believe that posting the position now would lead to a quick decision on a superintendent, which may or may not be the right decision of the right person. When you have a community as large as ours and a school district as large as ours, I'm adamant that you need to go out with a search firm, include the community. You don't always get it right, of course, but at least you're bringing in stakeholders, you're talking to staff, you're casting a large net, and you take the time to interview and to bring it down to a final three and a lone finalist, and it takes time. You can shorten that period, but to just open up a position just like it was another position within the district, I can't support that.
Thank you, Mr. Sitton. Ms. Lamont Dixon?
Yeah, I mean, I think I agree with most of what Mr. Sitton was saying. I do think we should hire a search firm. I think it's important to get feedback from the community on what they are wanting as well. I think there are more than one prongs to the process. I think as a board, yes, we can make a decision, but I think it's important to also include feedback from the community on what they would like to see, what priorities they have as a community. I believe the last time we hired a superintendent that like 1,000 community members were interviewed apparently. So I think it's important to include that part of the process. So I just wanted to just state that.
Yeah, Madam
Mr.
President.
Scarfo?
Yeah, thank you, Madam President. Is there any documentation of 1,000 interviews? That's a big number. And I'd like to see that if that really took place and was any records kept of what people said or didn't say, what their likes and dislikes were. It's easy to say 1,000 people were interviewed. I'm just not sure it's accurate. And I'm not saying because you're not saying something accurate, just I know you heard that information and I'm just having trouble with it. That's all.
Mr. Grabowski?
Yeah, just because we post it here soon doesn't mean we can't hire a search firm or take our time, or I think the sooner we post it, the sooner we'll have the resumes coming in. And if we don't see something we like, we just keep the process rolling until, if we decide to get a search firm, we get a search firm until we find the person that we like. I don't see anything wrong with posting it.
And I'll recognize myself. So posting it and asking for community feedback are not mutually exclusive of each other. Both can be done most certainly, and would be done most certainly. Ms. Lamont Dixon?
And Mr. Scarfo, you're right. I don't know if 1,000 people were interviewed. I just heard that number. But I was on a panel of community members in our group. So I can't say there were 1,000 people in the room when I was interviewed on the panel, but there were about 80 of us. But I don't know what happened prior to that or after I wasn't a board member. But there was a lot of feedback, a lot of questions on what we as community members and volunteers within the district, what we thought was important.
Mr. Sitton?
Well, I was there. We hired Hazard, Young, and Atia. They met with the chambers of commerce. They met with other business community members. They did town halls. They met with focus groups, parent groups, etc. They're the ones that gave us the number, and I'm sure there's a record of it. How many different groups that they talked to, how many people were in attendance in those. I know Miss Mount's group sent out surveys looking for feedback from community members, etc. So I don't think we can take this hire lightly, especially with what we've been through. And there is no way that Miss Mount and her team can put together an information item or a questionnaire to send out to the community in a timely fashion that would be indicative of what we're looking for, because we haven't even talked about what we're looking for in another superintendent. So I'm just going to caution everybody, don't rush into this. It's that vital and that important of a decision.
Anybody further? All those in favor? Oh.
I make a motion to move that Associate Superintendent, Mr. Rick Gardner, post the position of Superintendent of Schools on or before December 2nd, 2024, so that the board can consider hiring a superintendent of schools at a subsequent board meeting.
Yeah, Mr. Scarfo seconded. Okay, all those in favor? Opposed? Item passes 5-2. Item 4C, consider and take possible action regarding board authorization of public release of admitted record in the matter of Humble ISD versus E. Fagan, docket number 205-LH-08-2024 with appropriate legal redactions in the discretion of counsel. Mr. Holmes, do I have a motion?
Yes, I move that the board authorize the public release of the recommendation, hearing transcript, and admitted exhibits in the matter of Humble ISD versus Elizabeth Fagan, docket number 205-LH-08-2024, with appropriate legal redactions in the discretion of counsel.
Do I have a second?
Second.
Motion has been made by Mr. Holmes, seconded by Mr. Grabowski. Is there any discussion? All those in favor? Item passes 7-0. Moving on to our closing items, are there any topics for future board business? Mrs. Lamont Dixon?
Yes, I would like us to consider have on the December agenda an item to hire a search firm for a superintendent.
Is there any interest in that item at this time? So 3. Any other topics for future board business? With that, the time is now 8:34 p.m. This meeting is adjourned.